The principal ground of challenge is by citing the default of the lawyer. However, it is seen that the explanations pleadings made in this regard in paragraphs 9 and 12 are wholly insufficient and vague. On a specific query raised by the court, learned counsel for the petitioner responded that no complaint in the bar council against the concerned lawyer was lodged. Court has also noticed that even the name of the lawyer has not been stated. Be that as it may, in the interest of justice, this court had looked into the written statement filed in the proceedings under the IMDT Act from the records and found that there was no disclosure at all regarding any fact which should substantiate the claim of the petitioner regarding his citizenship. Though certain documents have been annexed to the writ petition, the said documents cannot be looked into by the court as that would amount to dispensing the requirement of proof of documents. We have dismissed the writ petition. This court has noticed that both the voter list of 1996 and 1997, apart from not being relevant, are uncertified copies and only translated copies. Court finds force in the argument of the learned standing counsel, who, by relying in the case of Isran Nessa, has submitted that such copies do not have any evidentiary value. The writ petition is dismissed.
मैं प्लीज योर लॉर्डशिप
In the written statement filed before the learned tribunal, the petitioner has stated that she was born in village so and so, and the name of the father is so and so, name of the mother is so and so. It is stated that the petitioner has six siblings and had got married in the year so and so and has 7 children. Voter list of 1960 and 70 has been annexed, which contains the name of her father and mother and brother. Another set of voter lists of the same years of 1966 and 70 have been annexed with the name of the petitioner and her husband. In the voters list of 1985, along with the petitioner, there are 2 new names, but her husband's name is not there. Voter list of 1997 is an uncertified copy, which, however, contains the name of her husband along with her and 3 other persons. Land document of 66-67 has also been referred to. As regards the land document allegedly containing the name of the father along with the petitioner, there are materials in record to show that the land was actually purchased by the father-in-law, and therefore the veracity of such documents becomes highly doubtful. We have also noticed that there is a clear stand on behalf of the petitioner of shifting from Shargaon village in the year 1970, as the whole village of Shargaon was washed away in floods. Therefore, land document of the year 2007 of the same village clearly appears to be clouded. Writ petition is accordingly dismissed. This court has noticed that in the written statement filed, the petitioner has not made the relevant disclosure. We have also perused the deposition of petitioner as DW1 and another person who has been projected himself to be the younger brother of DW2. As rightly pointed out by Sri so the Learned Standing Council, we have noticed that DW2 has not referred to any document ruling himself either with the petitioner or with the projected parents, and therefore his deposition is of no use. Deposition of DW1 is not acceptable at all, as there are not only contradictions in her cross-examination, she has categorically stated that she did not know anything about her chief examination. It may also be noted that the petitioner, as DW1, has stated that her father had no brothers, whereas in the written statement, she stated that she had 3 paternal uncles. After the discussion, we have dismissed the writ petition. And the IA has also accordingly been dismissed. I. That's my opinion. Itu Vishwas. This court finds force in the argument of Sri Kolita Learned Standing Council. Home Department that none of the documents which were placed on record before the tribunal would serve as a cogent, reliable, and acceptable evidence, and it is only the oral evidence which lies for consideration. The law is well settled that matters of present nature, oral evidence is to be substantiated by reliable, cogent, and acceptable evidence, which is relatable to the contemporaneous record. The petition is accordingly dismissed. Item number 3. Though this court is of a prima facie opinion that no case for interference is made out, as the reasons cited for non-appearance before the tribunal are absolutely vague and unacceptable, and rather the same reflect the negligence on the part of the petitioner to contest the proceeding. This court, in the interest of justice, have also looked into the materials which have been annexed to the petition. After perusal of the consideration of the materials, we do not find any case has been made out. The petition has been dismissed.
Yeah.
We found that the notice to the procedure was not duly served as per the provisions of Order 3, Rule 5, Order 3, 5, 6, Order 3, 5 of the 1964 order. Accordingly, we set aside the order, remanded back the matter for a fresh consideration. Petitioner has been directed to appear before the tribunal on 2nd of April 2024 and to file her written statement, affidavit in chief. You have directed. Yes, record to be returned to you.
May I please, Your Lordship? Lordship, I get to mention for item number C. Lordship, kindly adjourn the matter for 1 week.
The 2017 matter.
Lordship, my senior is suffering from viral fever, that's why it may be.
Okay, let the matter reach. Let the matter. First.
But let's hear it.
Okay. So,
May I please, Your Lordship? In this case, my lord, the engaged advocate is not available before this honorable court, my lord. Today, he is out of station, my lord. Sorry, matter may be taken in the next week,
it's a matter of very old matter.
my lord.
In fact, the petitioner hearing was made a deported. And the authorities did not refer the matter to.
Lordship, we have sent for the instruction. However, we have not yet received the
When
instruction.
did you send for the instruction?
However, we have a letter to the SP border Nagaon from the election officer
When
dated 1/3/24.
1,
3/24.
what happened prior to that? This order is of 2018. This order is of 2000. Please don't.
So date may be given, my lord.
18 of March. On the said date,
18 March.
the Superintendent of Police Border, Nagaon, respondent number 6, shall apprise the court whether the case of the petitioner, who is a devoter, has been referred to the Foreigners Tribunal for determination to whether he is foreigner or not. And if so, then next. If the case of the petitioner has already been referred to the Foreigners, then the status of the case. Finance Tribunal. Status of the Further, on the same date, next paragraph, the SP within bracket P Nova, correspondence, shall also apprise the court as to find the Election Commission of India and India. Election Commission of India as per number 3. Inform him regarding inform him to take necessary steps as the petition has been shown as the voter in the voter list of 2018. Copy of this order be furnished to Mr. G. Sharma, Standing Counsel, Home Department. Office. Order was of 2018. If you are communicating in 2024.
Table applies.
My lord, I received an instruction yesterday. Now regarding the financial implications that are connected with the opening of the portal, my lord, the finance department is yet to return as the file for which there is some delay here. Otherwise, my lord, the on the physical mode, my lord, we have instructed all the district officers, including inspectors and everybody, my lord, they have to take up all the steps.
Lordship, this instruction is coming for the last 7-8 months, same instruction, Lordship.
If the
Nothing has changed in their submission till date.
perhaps my
And
lord, if the
from
finance is made a party, they can
Lordship,
come up with
at
their.
this stage, they cannot take
I
up
don't
this
want
prayer
to
of
do it.
making finance the party, Lordship. By order dated 1/8/23, Lordship, they have been seeking time regarding the portal till date. Till date, Lordship, it was that it has to be placed before the cabinet. Today, they come up with a fresh new excuse that the finance has to be made a party. Inconsistent stand all through the last 6-7 months, Lordship.
RMS A. Verma, Senate Council in Hurst. Also heard Mr. R. Mazumdar, Kandy Council School Education Department. Mr. Chaudhary, are you appearing for?
Dr. Khan, appearing for respond number 13, 14, and 24, we have already complied with the directions of the Honorable Court. We are the Kendriya Vidyalaya Sangathan schools, and we have been following the mandate of the RTE Act for a very long time. So my affidavits are already on record.
Okay.
I do believe that the petitioner does not have any grievance against us.
Yes, we don't have.
I think my learned friend will agree that there's no grievance so far as these three respondents are concerned.
Okay. Yeah. During the deliberation of the matter, Mr. Mazumdar placed two communications. One from the Director of Elementary Education, Assam. The number E-445319 of the dated 07/02/2024. The other from the Director of Secondary Education, Assam. The number E-455629 13 dated 27/02/2024. From those two communications, we have seen that both the directors have informed the district elementary education officer as well as the inspector of schools of various districts of Assam, of all the districts of Assam, including the 6 civil districts of Karbi Angle, Dima Hassan, 100-year journey. To do the needful for successful implementation of section 12 within bracket 1 bracket 2 capital C of the Right to Education Act. On the next date fixed, both the Director of Elementary Education Assam as well as the Director of Secondary Education Assam shall individually file their respective affidavit stating the implementation of Section 12 within bracket 1 within bracket C of the right to education Act in each of the districts of Assam. And with respective reports from each of the DEO as well as the inspector of schools.
Lordship, what about the portal lordship? The activity calendar lordship, what they have submitted in these two notifications is only a
They-
repetition lordship.
As the session for the academic session of both elementary as well as secondary school in the state of Assam is going to start from 01/04/20 for the next 2025 from 01/04/2024. Both the directors noted above. And the said affidavit, in their said affidavit, shall also apply about the website/portal as required under Section 12(1). List on second April.
The website portal is to come from the government, matter the directors.
We don't know. The government is, you are also representing Commissioner Secretary, not only the
The
Commissioner
director, my lord, on her affidavit may not be in a position. my lord,
Director, as well as the Commissioner
to-
Secretary, the Education Department of the state.
My lord.
Shall also apply with-
Lordships, could our presence be perhaps dispensed with subjective lordships?
We do not have anything lordship against the private correspondence at all now at the moment.
Next date we will see.
Lot.
Mr.
Developed.
Now, let
Copy of the constitution certain we kept it part of the record.
oblige.
আরো এখন আরো একটা মাদক পাতাটা
May I please your lordship?
just a minute.
Lordship, kindly pass over the matter for one election.
Mr. Sharma. Counsel for the petitioner is unaware.
Yes.
For which says seeking time. But yesterday night while I was going through this, what we found, there are several adjournments from the side of the petitioner.
Yes.
Because matter is of 2017. The court wanted to take it back in fact 2018,
Yes, sir.
but then somehow it was passed over for the prayer of the council for petitioner and not for option. But as Mr. Mandal is sick, will not proceed today. But just verify whether the proceeding, this is a matter from Supri,
Yes, sir.
whether he appeared before the,
Yes, sir.
that's what we want. Right?
Yes,
How will
sir.
we able to get
Lordship, today itself.
try
I
to find
can-
out what you want to
It's
know?
a short date.
We will keep it short. Two 2017 matter, we'll have it on 14. Next,
Yes, sir.
what's your good name,
A. Ahmed. A. Ahmed.
full name,
Athia Akhtar Ahmed.
on behalf of Mr. M. Mondal, I am counsel for the petitioner service. That Mr. Mondal is indisposed. Very good adjournment of the matter. Matter is pending since January 2017. And records of the case have also been received by the agency in March 2017.
Sure.
Since that,
Huh?
considering that place this matter for hearing. Place this matter for hearing on 14.
Published.
In this case, my lord, from the year in 2017, my lord, case was notice issued on 7/2/17 till date, my lord, for every month after 15 days, petitioner is appearing, my lord, before the border SP, my lord.
Why?
I don't know, my lord, there was a condition, 24/2/24 also, my lord, he appeared. Last
Anyway,
night,
let us see.
yes,
Please proceed. We have the records now.
yes, my lord.
Mr. Payang, in Assamese there is a word Hilapai Chilamare, right?
Yes, sir.
Hilapai Chilamare, we are doing with him. Why these four agent persons are asking by the SP border to come every 2 weeks?
Every
That's not the order.
24 for all.
In fact, my lord, earlier this was the procedure, but we can instruct my lord.
Unless and until since the appeal has been
Yes, it-
admitted, its petition has been admitted and there is a stay order. But if violates that stay order, that is a different issue. Because we have
The
seen,
order is there.
we have passed orders vacating those stay orders, right? As did not appeal. That is a different issue. Anyway, Mr. Das, please start. Okay, please take your seat.
Yes,
Wait, let us. That's the task, how you have proved the case.
But here, my lord, according to me, my lord,
There were husband and wife.
yes,
There are
husband and
two
wife.
different reference. And
Lordship.
the, both the reference was.
Earlier, there was
taken up together.
IMDT case, my lord.
Hmm.
IMDT case 546, 547.
Hmm.
Subsequently, it is, my lord, renumbered by after the, my lord, abolition of this act, my lord. And in that case, my lord, they have submitted some documents, NRC documents 1951, but only because of the some linkage, my lord, that has
Definitely.
been mentioned, my lord. But otherwise, he was born and brought up Lankishinga, my lord, Poralipara Part 2, my lord. From the year 1951, it is reflected, my lord, from the legacy data, total list, etc. Similarly, the petitioner, one's wife, petitioner number 2, my lord, she did not cast vote, my lord, before her marriage. Subsequently, her marriage was solemnized in the year 1980. And after 80, she, my lord, casted her vote, my lord, in the four times, my lord. Subsequently, they have shifted from one place to another place, my lord. Poralipara to Kollanpur, and my lord, this Kollanpur, my lord. And subsequently, their names were, my lord, reflected in the Gwalpara town, also, my lord. From the year 2009, it has been, my lord, they have been, as there is no linkage, and not, there are so many, my lord, typographical mistakes maybe, my lord, because these persons, my lord, wrongly, my lord, on the basis of the some information from the local people, they put their names, my lord, by their nicknames, my lord. These are the problems, my lord. Petitioner number one's father, my lord, as mentioned here, my lord. Desarat Das petition number and his Gedaru Das. This name has been reflected as Gedaru Ram Das, Gedaru Das, Gedaru Has. Similarly, the father of the petitioner number 2 also, my lord. Monoram, Konoram, in this way, my lord. If it just heard and the person concerned who put their names, my lord, in the said voter list at the time of survey, possibly, my lord, heard and put their names, but they cannot be able to, my lord, submit their form properly. That's why these mistakes have been kept in, my lord. And here also mentioned some records of the, my lord, land documents also, as it is reflected, my lord, paragraph, page 23, my lord. Page 23, paragraph 12. May I read, my lord?
Just a minute. How you have proved the linkage of.
Yes, my lord. Paragraph 12, my lord. On examination of the exhibit FT case number so it is found that exhibit A is land revenue receipt in the name of Gedaru Ram Das, which was issued on 30/12/65. Exhibit 1A1 is copy of the Kesapatta in the name of Gedaru Ram Das, son of Bodon Chandra Das, which was issued in the year 14/9/1984 by the settlement officer Gwalpara, Dhubri NRC. Details with Xerox copy of the NRC is found illegible and not exhibited, so NRC is liable to be discarded. Exhibit C is the certified copy of the voter list of 1970 from the village Poralipara Part 2, where name of the Gedaru Ram Das, son of Bodon Chandra Das, and Felai Das, Felai Bala, wife of Gedaru Ram Das, was enrolled at serial number so and so. Number nil. Exhibit D is the certified copy of the voter list 1985 Boralipara Part 2, where names of Dasarath Das, son of late Godaru Ram Das, wife of Dasarath, were enrolled at serial number 236, 237, house number so and so. That means, my lord, it is in the voter list NRC 51, it is mentioned, and in the voter list of 66 also, that is mentioned. As I have annexed here, my lord, in the additional affidavit here, it is seen that, my lord, his name Gedaru Ram Das, in the, my lord, NRC copy, it is there, my lord. Gedaru Ram Das, in 1970, it is there, Gedaru Ram Das, and connected, my lord, and 1975 also, Gedaru Ram Das and Dasarath Das, that is mentioned in the voter list of 75. Translated Dasarath Das at original copy is, that is page 17 in additional affidavit in local vernacular 358 Dasarath Das, and also Dasarath Das, that is mentioned here. Gedaru Ram Das also here 355, 350, it is sufficient, my lord. In the total list of 85 also, I have an
How you have connected yourself with Gedaru Ram Das?
yes, my lord. This is total list of the year, my lord, 1975.
Is it certified copy?
That is not certificate copy.
Then
Possibly that is in the record also, maybe. I have
if
to
it is
check.
not certified copy, as you know, secondary copy is a public document. It has
Hmm.
to be certified copy. What stopped you from producing it?
But certificate copy also here, in 85 total list.
85 hotel list,
Yes,
75.
yes, 75 yes. Dasarath Das let Gedaru. That is mentioned.
We have nothing to do with Gedaru Ram Das. Show your connection with Gedaru. That's all. How you have proved it?
Then it is mentioned from the above facts, it is disclosed that by exhibit, it is found that the name mentioned in exhibit A, father, on the other hand, extract copy of the voter list 75 shows enrollment of the respondent Dr. Dasarath Das name along with his father, which give rise to the fact that Dasarath Das was at Boralipara Part 2 in the year 75. To decide the allegation base here is the 66 or prior to that, but the respondent failed to submit convincing document to show that his father Gedaru Ram Das resided at prior to 66. But it is possibly not correct, this finding, my lord.
Why your name did not figure with your parents?
Additional affidavit file, my lord.
We understood.
Hmm.
Additional file, affidavit file by what will, how will you develop it?
Yes, yes. Except the, my lord, this total list of
have
75.
66 and 70 of your projected path.
Hmm.
Fine.
75, this copy is there, my lord.
Hmm?
75 copy total list. Certificate copy is not available, but here it is both father's name, mother's name are all mentioned. Page 13.
During the NRC time, these kind of documents were available in every pan shop.
Pancham, I don't know, my lord, but
Right.
without any
But thing
linkage,
is, why-
or how can they, my
What
lord?
stopped you to have it, the certified copy of 1970 were properly, if your name figured along with your father?
Then, my lord, I have to collect that
Now
certified
collecting,
copy,
how will you be benefited? That's why we are asking you.
75 total list. Hmm? 85. The exhibit, they failed to exhibit also, my lord. Oh, that's a teacher.
Yes, Mr. Pai.
First of all, my lord, he's relying the NRC document. NRC itself is not admissible. It is
And I think his father may be
Yes.
there, but his name is not there.
his name is project. My lord, even though it is not an admissible document, this is settled. Secondly, my lord, the petitioner fails to link himself. Petitioner number one with my lord his parent. My lord, there is no documents at all to establish that the petitioner is the son of Geduram Sikh, Geduram Das
Yeah.
of my lord this village Bodolipara.
Initially, he was at Bharalipa.
Yes, initially the Geduram's voter list of 1966 is my lord of Bodolipara. Then my lord, the petitioner is
We have nothing to do with the Geturam.
yes, we have nothing to do with the Geduram Das of my lord Bodolipara. Now, if he is claiming that that person is his father, then he has to establish that. There is no murder evidence in record to show that the petitioner is the son of that Geduram Das of Horolipara. To that effect, there is no evidence. No evidence at all. Even oral evidence also there is no evidence. The petitioner is of my lord. His voter list, first his name appears in the voter list as per the my lord, the order, because the exhibits are not here. As per the order, my lord, the respondent Dasarath names was enrolled in the voter list of 1997
That we have
from
seen.
Bolotmari village, my lord. That is in case of my lord, petition number one. Here is my lord, your lordship will find.
75, 85, 86.
75 was not
85.
agree.
Additional repeat. Page 70.
Respondent name was enrolled in the voter list of 1985. Yeah, ma'am.
Together.
I agree. My lord, may can you see, my learned friend is my lord, are pointing out this, my lord, the voter list of 1975. This was not exhibited before the tribunal. And this is not a certified copy, first of all. Secondly, this was not exhibited before the tribunal. So it was not under consideration in the tribunal. The
Right.
yes.
Mr. Das, just tell us one thing. You are saying in 1985, you had cast vote at Bharalipa in your written statement.
Yes, yes,
In 97 at Baldamari.
yes. From 97 at Golpara.
Then from 2009 onwards at Gwalpara.
And
Right.
from 1997 onwards in Golpara.
But in your
Kollanpur,
written statement,
Golpara.
you did not say anything that you have shifted to Baldamari at any point of time. You said you are casting your vote at Pitbari.
Pitbari, Golpara town. Bolotmari, or Golpara. Kollanpur also in 75 to 96, Lengti Singha, he casted vote. From 97 at Golpara.
No, in your written statement, you are silent. With regard to Baldamari. You only say they have shifted to Pildanpur.
1990, Pitbari, Golpara.
How you have proved your link? 75 voter list is not a certified copy.
Hmm.
At least your name should have been there along with your father somewhere.
85 certified copy, my lord.
Along with your father.
Yes, my lord. Because
Showing
my
your
father
father is
expired.
also when
85 it is there, my lord, but late Gadaru is mentioned here. But my father was expired at that time.
prior to that, there are many elections prior to that.
Prior to that, 75 is there, as I have got the one extra copy of the
But
voter list.
75 is not your certified copy.
Yes, not certified copy.
Then how can it be accepted? Then evidence.
National পিছু কারো এখন করছে নাকি?
What about your wife? The other proceeding?
Yes, my lord. Other proceeding, my lord, Kusumbala Das is my wife, my lord. Prior to my marriage, my lord, I did not cast vote there in my original place. Subsequently, after marriage, her name has been reflected in the voter list, my lord. As I have, I'm
How you have shown that you are the daughter of Honaram Das?
Sonaram Das, my lord.
Where from? Who proved it?
Here, my lord, only the voter list 1966 certificate copy is there, but her name not along with the that voter list, my lord. Sonaram. One certificate was issued, my lord, saying page 32. But here also her name is not. This is certificate as Konaram Das, son of so and so, senior police station Bizni, district of Gwalpara in the state of Santu, district so and so, is scheduled so and so. Sri Konaram Das and his her family ordinary reside in the village Simlawari of Gwalpara district of the state of Assam. Just issued 13 to 17. But
This certificate also you have not proved.
yes, my lord.
Again,
Connection is not there. Linkage not there. Only on the ground, my
that is
lord.
also illegal because it is the government of Assam. Oh, the circle office. Not the panchayat. Whether the Latmandal can issue, circle officer can issue such a certificate or the panchayat secretary. Mr. Payang,
Well, in fact,
was there any authority to provide such certificate?
residential certificate, my lord, PRC is issued.
Caste certificate.
Caste certificate should be issued by the deputy commissioner
No.
on the recommendation of the my lord.
Just like the Gaon Panchayat secretary.
Yes.
The petitioner also obtained a certificate from Latmandal with signature of the circle office from Bizni.
My lord, I don't know whether there is any provision. In fact, my lord, I think there is no provision at all for the Latmandal to issue such certificate.
The Latmandal normally other certificate.
Yes.
They are said to give the report.
Yes,
It is-
they give a report.
He gives the certificate, but only the circle officer endorsed it. That's all.
Yes, much. In fact, the my lord, Latmandals can give on the report on the request on the of the circle officer or on the my lord, inquiry made by the circle officer. Latmandal himself cannot issue certificate as such much.
Yes, Mr. Das, show us. Otherwise, you know the consequences. Both the husband and wife. From where will you show?
Voter ID, my lord, I have that copy, one copy.
Authorized is not.
Yes, my lord. Valid document. Subsequently, my lord,
Your, has there been a voter list of 1975 which you along with your parents? That could have been different.
Hmm.
How will you establish that you are the son of Geduram Das? Similarly, how the other procedure proves that he is the daughter of Panaram Das? Where is the link?
my lord, two copy I have along with me, my lord. Here, my lord, it is mentioned 1970, and my lord, it is possibly certified copy. One Xerox copy is there.
What is this?
Geduram Das, his father's name.
Petitioner লগত কপি কৰ
It is Ojita. IT Ojita. That's all. Family 2 to 70, that's it. Hmm.
Sir, buying, is it believable?
My lord, this is what I'm saying, my lord. Geduram Das was there. We have no issue on that.
The link between.
Link between Geduram Das and common voter list between
Any
among
voter list with Geduram Das.
Geduram Das and Dasarat Das.
My lord, Monday, my lord.
Why the proceeding did not give certified copy of voter list of 1975?
In the meantime, if there, my lord, I will correct, collect, my lord. Monday, my lord.
How will you collect?
I have to take instruction because they are me in communication, my lord.
My lord, in fact, even though it is collected now, this cannot be appreciated before the honorable court.
No. It so happen it is a certified copy of the voter list. Where it's 75, that will be a different issue.
Yes, my lord, that would be a different issue. But neither he has mentioned about the 1975 voter list in,
But reveals on voter list of 1975. But that's not certified.
no, my lord, one in WS, he has not mentioned anything about it.
Nothing. He mentioned about, in fact.
Everything he mentioned, but he has not mentioned 75.
66 and 70.
66 and 70.
Nothing about 75 voter list.
Yes, nothing about 75 voter list. Mention about 85, 97, 2009,
That is about him.
2016. Yes,
That is about him.
yes.
But with regard to his own. father,
Evidence in chief, it is mentioned.
If it is not there in pleadings, how will
Yes.
you extend it?
Evidence in chief.
How will you
different-
extend it?
Council, another council possibly file a affidavit,
Yeah.
file this additional affidavit. And that's why possibly,
Whatever is in the knowledge of the proceeding, that
Hmm.
only it will. file by
page
the
6,
council.
my lord, I have seen page 6 of my additional affidavit.
That will not help you, Mr.
Hmm.
Clerk.
Yes, my lord, that my name has been enlisted in voter list of 75, 85. That is there.
You have stated that your name figured in the voter list of 97.
Yes,
And in your affidavit, you have said your written statement, name of your father figured in 1970. And after that, no voter list of 1970 of your father.
Hmm.
So
Evidence in chief. Hmm. Hmm. evidence minus. Tapi asli. It's when I'm still over like it.
What is in your cross? Do you have any cross?
Cross I have
Itu connect to connect. Untuk protocol of the from here. Itu
gimana? Jadi Hmm? Ya, tadi kalau ya, tujuan tujuan itu nama omong aku istirahat tujuan ini milik. Nah,
No materials. Mr. Das,
Lordship,
there's a difference of your exhibits. Also.
Hmm.
Your exhibit CD not in conformity with section 76, whereas your voter list, the voter list of your parents,
Hmm.
not certified copy. Whereas you can see of your own voter list, the certified. You can see. Bro. Mr. Payang, have you gone through the record?
No, my lord, we
Go
can
through,
check.
you know, what is happening here. Right, okay. Right. Yes. Right. Yes, that is okay. Yes, that is-
Thank
that lady is in custody. But it does not take- Very easy to tell and pen drive. My pen drive to release to them. To order to get it part of the- no, our petition due to price. Okay. Where is Mr. Sharma? Is in Adapur? You can see CD and his own voter list of 97, how it is, why it is certified copy.
Certified copy and the Xerox copy are not similar.
No, not that.
No, no.
Down below you'll see. Look at your own certified copy of voter list of 97, you'll realize. whom recommend. Mr. Sharma, that yesterday's matter likely to come out today. That service that matter who is in custody, detained in Patia. That lady. We are setting aside that all and directing her to appear before the tribunal on 2nd of April. Right? So since it is, we are setting aside, she has to be released forthwith, which other things will not come. Only the release order may be required, release order to, it's not. You have to complete. No. Once the order is set aside, why she has to appear before the. Yes, yes, you have already fixed the 2nd of April.
Yes, she will appear on that day.
2nd of April, she will appear before the tribunal
In the,
at Corbetta.
in the meantime, she may be released.
Do you want to place anything else? You have seen
Not
both the husband and wife
fail to
fail to connect
Linkage.
themselves with their
Correct.
projected father and mother.
that is
How-
correct.
And you see, if any voter list, you say with regard to wife, there is no voter list.
Mhm.
Possibly for the husband, it's number one, there may be a voter list of 75.
Mhm.
Now, if you want to have that, you must have that voter list certified copy. And the first two certified copies of Keduram Das are not certified copy as provided under section 76. You have seen, but your voter list, the certified copy, it's two certified.
Yes.
That's how it's the given normal.
Mhm.
But your annexer C and D are not certified.
Paper of my wife's are there.
We have seen,
That
but
is
no link.
certificate to it, but no link. That is correct. I have in my lab.
How do you do? You know the outcome. If you cannot prove the link, will
Yeah, with some time my lab, 14. That is be my lab, take instruction. If there is any email such on 14.
the Jan secretary. Will not make it a part hard in that case. My brother will not be available on next week. The prayer of Mr. H. List of food.
14 minutes.
We're not saying anything.
Yes, madam. If there is anything ballot, I will individually collect madam. If nothing ballot.
May please the lordship. My lord, in this matter, my lord, I have done the record, my lord, that the linkage document was not, my lord, properly submitted, my lord, or placed, my lord. Though one of the linkage document was mentioned in the WS, but it is not exhibited, my lord. The Indian judgment, my lord, page number 34.
In fact, Mr. Payeng, the recent judgment regarding tertiary, which you have been citing, you go to the other Supreme Court judgment, there are full bench judgment, Constitution bench judgment of 5 judges, Constitution bench judgment of 7. Issues are different. But in all those matters, if you go through, you'll see that they have discussed about the writ of cessation. In that recent judgment, SCC online judgment, how come it has not been, it has been reported only in AIR, judgment today, another, not in SCC, and not even in others. I found very surprising. Anyway, in that judgment, there were discussion on 2 such judgments of 61, 65. But in between, there are judgments of full court, 3 judges
Yes, ma'am. That is
and
it.
5 judges. How they have discussed, if sometimes to read, because issues are of course different,
Different.
but they have discussed about certiorari. So those judgments are quite long, but find out from there.
I'll go
And
for it.
then they discussed about certiorari in such a manner. I was feeling those judgments we have been passed earlier will have no leg to stand. Yesterday, some judgment was placed, was a little hesitant. That's why yesterday night I tried to find out. Those judgments are
Understood.
there. As on date, they are. So, but whatever they say,
Yes, my lord, I understand, my lord. So in fact, I argued those points.
yesterday, meant it should
Yes.
have to some
Yes.
their home department.
Yes, yes. We are
See, in one of the judgment, the apex court have clarified. It's all 60s to 75. And
yes, ma'am.
they have clarified when only the High Court can intervene. For certiorari, it must be positive.
Yes.
The next condition, Secretary take this. Then next condition, which the constitutional authority or the procedure is followed,
Yes,
right? Whether notice was given or the notice was duly served or not. The proceeding, because it is not only in the case of furnace tribe,
yes.
maybe other tribunal.
Other tribunals also.
So in those matters, once it is now the notice has been served, the concerned incumbent can into it, file, reply or whatever. Then they came the error apparent on the face of the record.
Yes.
Now, what is error apparent on the face of the record?
That is
More
also clear.
particularly which certiorari? They have not discussed with the CPC provisions.
Yes.
They have discussed of their own about the writ because these are prerogative writs. So these writs how to be exercised.
In fact, my lord, what my submission will be, what I have observed, my lord, in case of other tribunals, suppose CAT, my lord, motor accident tribunals, in that case, the court is strictly, my lord, following the certiorari jurisdiction, strictly following the principles of certiorari jurisdiction.
No, thing is this only reason is here you have section 9
Yes. Yeah.
and you will not get much of cases of foreigners tribunal. You will get the cases of other tribunals.
Yes, my lord.
So in those matters, because I was trying to find out what the Honorable Apex Court in earlier cases tried to clarify. Now we have to see together with section 9. So wherever you get time to do some exercise, this is the
Yes.
reason why I'm saying, because they are saying what will be the error apparent on the face record, on the face of the record for the court under 226 to interfere
Yes.
with the decision of the tribunal, whatever the last judgment you are suggesting, I
Yes.
was that even the order of the tribunal is bad,
Then also,
finding is bad. But if these things are not there, it was
Yeah.
already decided in a matter of 1962.
Yes, my
by
lord.
three judges. They have clarified and subsequent judgments, because one Honorable Justice Gajendra Gadkar was there. In most of the cases, you will see his report. And in fact, those 7 judges case, the constitution based judgment, and whether it is 5 judges or 7 judges, with regard to certiorari issues, not the Foreigners Act.
Yes.
There they have been clarifying. In fact, all the 7 judges, all the 5 judges, honorable judges have clarified, and then they have come to the conclusion that this is.
What
But
my-
it's a very lengthy judgment, and the issue is not directly to the point of
involved with the, my lord, foreigners
Foreigners-
tribunal.
tribunal. But if you read slowly, and you'll realize how they have acted on it. And about the error apparent to face of the record in exercising the power of the certiorari, they have clarified in a better way. That is
lord.
why it was in the last case, all have been summed up.
Yes.
And if the reason is, if you have to know it, you have to go to the facts of the case, those matters particularly. And see the standing, that was yesterday I was little that Anjana Biswas.
My lord, what my contention is that, my lord, your lordship, when sitting under certiorari jurisdiction, your lordship is strictly my lord, following the certiorari jurisdiction under 226, my lord, certiorari jurisdiction, when it is in case of CAT, MAT, or my lord,
tribunal.
any tribunal. But it's relaxing, my lord, when it comes under, my lord, the foreigners tribunal.
No, that thing is.
That
not
is
there.
the issue
No,
in
that
some
is not the
cases,
issue.
my lord.
They cannot. That is the reason why.
It cannot be, my lord.
If you read the judgment of the 7 judges court, the constitution bench judgment consisting of 7 judges.
In
Constitution
fact, my
bench
lord, this,
consisting of 5 judges. Why it cannot?
yes.
That reason is also there.
And in fact, this honorable court in full bench, my lord, Muslim Mandal, has clearly said you cannot go beyond 220.
There is a
certiorari.
case of 1962 from
Yes.
Assam. I forgot the name of the party. I have to just check. It's a 1962 matter from Assam. It was decided by the apex court. At that point of time, the Guwahati High Court decided what is certiorari, and it was upheld. And in that, I'll just some Borua, should be Borua or Bora, I forgot the name. And then
Let me check out, my
it
lord.
is very important. There, our High Court have clarified why it cannot be interfered, and that went to the apex court and apex court uphold that judgment of the Guwahati High Court. It's important because somewhere
Yes. Understood.
the
Sir,
relaxation, it's not like we are not exercising the other great jurisdiction. We are
Yes, ma'am.
exercising only certiorari.
certiorari. That's why I always submit that point, my lord.
No,
we are
normally
under
it
certiorari.
happens that writ court will have that tendency,
To
right?
go beyond, my lord.
Yeah, definitely. Any writ court will have
Yes.
tendency. Why not? It can be.
Yes, yes.
The thing is that's how if you read the old judgment, you see how they have differentiated this.
Yes.
Why only in certiorari we have to confine in that area, and we cannot go beyond the other.
And
Why not lie out?
why I submitted, my lord, this the Muslim Mandal, because Muslim Mandal has specifically said that, and my lord, even though because the tribunal, foreigners tribunal is specially for the state of Assam. It is
But,
nowhere in the
It will be
India.
difficult if the Anjana Biswas stands. You have to do something.
that we are thinking about that, my lord. In fact, my submission of it, that is as it is, it ignored the full bench decision. It will my lord, par in Korea. It's ignored the full bench decision. It is settled position of law. If it is ignored, it will be a par in Korea, my lord. My-
Even the other judgment which was shown, Inaram or something, money rule or
Yes, money.
that also,
Yes,
that exercise is, though they said Sirazul.
Yes.
But thing is this Sirazul is something different.
Sirazul is different.
And you'll never see in any of the judgment by the apex court, there was nothing to pick and choose on behalf of any such voter list.
Yes, ma'am.
Because it is under the Representation of the People Act. That's absolutely again a different kind of act. And that is the background of Kafatullah, Ahmedullah, and
Sure,
Sirazul.
I admit,
They
my
have
lord,
considered that because the names of the other persons in the
are
voter list
available
remain
in the same voter list.
Here the names are same, only
Yes.
with the one person there is a difference. That is in that background, the honorable apex court has accepted that.
That is also A become M become F. That possible.
So just picking up two lines from that will not be enough.
It has to be read entirely.
So that is the reason. But see what is to be done. Yes,
Yes. So my lord, in this matter, my lord,
how
the,
you have proved the link?
yes, my lord, that is, my lord, the link is, my lord, 1993,
You want to show that you are the daughter of Anwar
19, yes, my lord, page number,
Ali.
Anwar Ali, but my lord, it is mentioned wrongly as Anwar Ali, my lord. Page number 20. Amarun Nisa is her mother. She is Rukia Begum. My lord, in earlier documents of her father's voter list, it is Anwar Ali, my lord, from 66 onwards, my lord. 66 NRC is there, my lord. Anwar Ali, son of Abdul Mojid, page
Which
number
is your
5.
link document.
Yes, my lord, this page number 20. Page number 20, my lord, 1993 voter list is the link document, but it is, my lord, Anwar Ali instead of Anwar Ali, my lord. Mother's name and daughter's name is there. Then, my lord, one marriage certificate, page number 26. During NRC, my lord, the Gao Panchayat had issued this migration certificate, my lord. But these documents was not exhibited, my lord, before the tribunal, my lord. And 36 is a school certificate also, my lord. Father's name is mentioned. Anwar Ali, my lord. The 1993 voter list is, my lord, is a certified copy, but the father's name is wrongly written, my lord. There is no change of village, my lord. The same village he was born and brought up, my lord. And only after marriage, the village is changed, my lord. from 1966, my lord. Same village is there, my lord.
Please come to your
Yes, my lord.
page number.
Page number 33, my lord.
Yes.
Yes. I have submitted my examination in chief through an affidavit by the exhibit A. I was born and brought up village Sejpur, part 5, PS Silchar, district Kachar, Assam. My father's name appeared in the voter list of 66 by serial number 261, house number 55 at Sejpur, part 5, under LA12 United Constituency. My father's name appeared in the voter list of 75 by serial number 310 and house number 50 at village Sejpur, part 5, under LA10 Sunai Constituency. Exhibit 2, my father's name appeared in the voter list of 85 but serial number 119, house number 44, Sojpur, part 5, LA Sunai Constituency. I did not cast any vote at my parents' house before my marriage.
I did not cast any vote at my parents' house before my marriage,
Yes, ma'am.
right?
Yes, ma'am.
Then proceed.
I cast my vote after my marriage at my husband's house. My name appeared in the voter list of 97, but serial number 622, house number 562 at Danehari, part 2, under LA 10, Sunai Constituency. Exhibit 4, my name appeared in the voter list of 2005, serial number 12, so Danehari, Sunai Constituency. My name appeared. So after marriage, we mentioned.
So necessarily.
Yes.
This 1993 voter list that which you have annexed here, page 20
Yes, my
or
lord.
19,
Yes, my lord.
it's a manufactured document.
Yeah.
You, because all knowledge are with you,
Yes, my lord.
you yourself admitted before the tribunal
Yes, my
by
lord.
adducing evidence in court
Yes.
that your name figured in the voter list for the first time in the year 1997.
First time not mentioned, my lord. My humble submission only mentioned 97. And
He said, I cast my vote after my marriage at my husband's house.
yes, my lord. 97, she
And
was
before
married.
that, she did not.
He did not, my lord.
So if her name would have been there in the 93 voter list, she would have definitely.
Yes, my lord. She did not mention, but my lord, this certified, it is a certified copy, my lord, obtained in 2016, my lord, after the judgment, my lord.
If you have not said anything in your written statement.
Written
in
statement, my
that
lord.
regard, why?
Yes, my lord. Written statement is not there in the evidence also, my lord.
So in your written statement, you are totally silent in that regard.
Yes, my lord. Page number 28, my lord. Not mentioned, my lord.
In the written statement, you clearly stated that your name figured in the voter list of 2013. You have also not mentioned about 1997.
Yes, my lord. Only the migration certificate is mentioned, my lord. Paragraph number 8, my lord. Paragraph number 8, page 29, my lord. Where the father's name is, my lord, available, my lord. The certificate is page 26, my lord.
That will not help you. Come to page number 29. That's your written evidence,
Yes,
right?
yes, my lord.
Written
29 is
statement
the
or written
WS.
evidence?
my lord.
Okay,
WS 31 is the my lord.
okay, you come to page number 31.
31 my lord.
Read para 3, 4, 5, 6.
Yes, my lord. Originally, father's name has been recorded. Bhutan list of 1966. So and so, my lord. Serial number so and so. Originally, father's name recorded 1975. Serial number constituency so and so, my lord. And originally, father's name has been recorded 85. And then my name has been recorded Bhutan list 97.
Not in 1993.
Not mentioned, my lord. It is
So-
not mentioned. So, my
And
lord,
that also with your husband.
husband, my lord. 97 is husband, my lord. 27 married. So, my lord, some of the, my lord, these are due to the, my lord, I have not to mention that the council's, my lord, duty was to, my lord, prepare me
No,
properly,
that's
my
what,
lord.
you
That was, my
know,
lord.
every time is not council. Sometimes councils also helps you.
Yes, my lord.
See, you
But-
have filed your affidavit, written statement in 2015,
Yes, my lord.
and all these documents are of 2016.
Written document, my lord, these are filed, my lord,
So these
16,
documents are not there before you.
16, my lord.
Somehow you have procured. No,
Well-
written statement is of 2015.
Written test of
Come to page
15.
number 20.
Yes, my lord, 15 and evidence is 16, my lord.
So
And
all these documents, that is the reason you have not mentioned about these documents in your written statement.
yes, my lord, it is
And you
after the
cannot-
judgment.
You cannot go beyond what you have stated in your written statement.
Yes, my lord, that is the reason, my lord. The this, my lord, the
So was the link document between you and your father.
yes, my lord. That is page 21 and 26, my lord.
Hmm.
26 is the certificate, my lord, issued by
By
the
whom?
Gao Panchayat secretary,
Panchayat.
countersigned by the block development officer, my lord.
Countersigned by the block development officer.
Block
Have you
development
noticed
officer.
one thing in that certificate? Have you noticed one? Look at the top.
Yes, my lord.
Gao Panchayat is government of Assam.
Office of the secretary. No, no, my lord.
So
Though it is mentioned, my lord.
being home ministry, you are representing Mr. Payang, home ministry. Why are you not taking actions against this person? You are not other department.
Yes.
Where is their authority?
Development officer is also countersigned, my lord. He is a government officer, block development.
Whether this person have adduced any evidence?
No, my lord.
This document, this certificate has been proved.
No, no, my lord. This is, my lord, also, my lord, mentioned in the WS, but it is not exhibited, my lord. It is not exhibited, my lord, this document. In the evidence is in chief, my lord. Page number 31, my lord.
Why you have not exhibited?
But this is also, my lord, one of the reason I have been instructed, my lord, that, regarding the everything was depend on the council,
Your
my lord.
exhibit one was 1966 voter list of your father.
Yes, my lord.
Exhibit 2 is the 1975 voter list of your father. Exhibit 3 is your, again, voter list of your father, 1985. Exhibit 4 is your voter list of 1997. Exhibit 5 is the voter list of 2005. And Exhibit 6 is the voter list of 2015.
Yes, my lord. No link document is exhibited, my lord.
So
No link document is exhibited, my lord. Though mentioned in the WS, this link document.
it was the only document you had at that point of time.
Yes, my lord. Only document, my lord. And after the judgment was delivered, this, my lord, is obtained the 93, my lord, the Bhutan list. my lord.
Yes, Mr. Payang,
My lord, may kindly,
this you have seen already.
yes, my lord, your
Voter list
lordship,
of 66 of one Anfar Ali.
yes. Only my point
Then
is,
voter list of 1975 Anfar Ali.
75 is unfairly, 85 is also unfairly, my lord. Now, my learned friend is relying that 93, though it was not submitted before the tribunal, my lord,
That was not sir.
that is not submitted. Even then, my lord, this 93 is with Emarun Nessa. There, the husband name is different. Anyer Ali.
Try to match up somehow.
Yes. And
That is the reason probably it was not exhibited.
yes, and secondly, my lord, your lordship may kindly see the WS, my lord. Page 20, page,
There is no name of father and mother.
yes,
If you read
no
the-
name of father and mother, my lord, no. In fact, it's totally inadequate, my lord, the WS. No name, when the father died, what happened to father? If father was alive, my lord, the father name should also be there in 1993, literally. That apart, my lord. So if as 93 was not exhibited, this cannot be accepted as a document, my lord, at this stage. But even though we go, my lord, this 93 has no relevancy at all because it doesn't prove any way the petitioner as the daughter of Anwar Ali of 1971. Then if this was not exhibited, there is no document of all, my lord. Not even oral evidence also. There is no oral evidence also with regard to that matter.
No, some evidence. That is the only evidence which Mr. Kadir has just read.
Rukia Begum. OP has been cross-examined. OP has been cross-examined. The Panchayat secretary was not called. He was not
No,
examined.
that document is not
That
exhibited.
document was not exhibited at all. So there is no linked document at all, ma'am. So in absence of linked document and proof of any kind, that the petitioner is the Anwar Ali of 1971. The petitioner failed to establish her citizenship. Nothing has been disclosed in the WS. ma'am. Neither her date of birth.
Father, nothing.
Yes, madam.
But
Neither.
later on, he projected that she is daughter of
Yes.
Anwar Ali.
Nothing has been disclosed.
But notice was issued in the name of daughter of Anwar Ali.
That is true, madam. Yes, that is for identification.
And by this name, she has been identified, my lord, in the notice, my lord. He
No,
received
during
the,
the inquiry, she said her father's name.
Yes, yes.
It is here. That's the reason they've been going through.
Enquiry did madam. Notice is given on the basis of enquiry. only.
Yes.
Okay.
Yes, Mr. Kadir, please.
my lord, regarding my lord, this notice, my lord, since during inquiry, my lord, it is found that she is the daughter of my lord Rukia Begum,
No, no,
which my lord,
Not daughter. She named her.
yes, my lord, named Anwar Ali, daughter of Anwar Ali, my lord. And my lord, since my lord, admittedly, my lord, there was no link document, my lord, exhibited, my lord. And, but she has the documents, my lord, at least this certificate, my lord, of migration. So, my lord, may I pray for some accommodation, my lord, regarding, my lord, this, my lord, in the absence of any exhibited documents of the link, my lord, may I have some accommodation to place
See,
any
That's what we're discussing, you have heard.
1 week time, maybe, my lord,
Even if you
accommodated.
produce a document today, how it will help you? Was
Yes,
it before
ma'am.
the tribunal?
Yes, and on this point, my lord, may I accommodate in some 1 week time, my lord, if I can, my lord, submit some decisions, my lord.
Beyond pleading.
Yes,
Now you cannot change your pleading.
yes, this is
So
right.
if it is not in pleading, how will you bring it by, let us say you have a document.
Yes,
How will you bring it? It is not in your pleading.
yes, ma'am. Other,
And that is why the constitution that 62
yes,
with regard to the foreigner
yes,
act clarified because why the burden doesn't sit to us.
yes.
Reason is only with the knowledge of the
Personal knowledge.
clear.
Personal knowledge of the person.
That is the main issue.
Yes, ma'am.
So if the proceeding fails to place anything before the tribunal
Yes, ma'am.
or fails to disclose,
Yes,
then that cannot again be
Ye-
considered.
definitely. But in the some of the decisions, my lord, of this High Court, my lord, the this honorable court held that the claim of the petitionership remained uncontroverted in cross-examination, my lord.
Cross-examination is not required. Here also you see Apex Court has clarified
Yes,
that it is the proceeding who have to play.
yes,
And if it is just, you see, order 3 of 64 orders,
good. Okay. Very nice.
you have the orders.
Yes.
Now just see. Order 3, 9, 10. Read 10. Order 3, 1, 2, 3, 4, then come to 10.
10. The foreigners tribunal shall take such evidence as may be produced by the concerned superintendent of
Then the
police.
next line.
11. The foreigners tribunal shall hear such persons as in its opinion are required to be heard.
That's all.
Yes.
It is whether there is a cross objection or something, it is not required, nothing.
Yes, sir.
And you see this particular order has been framed under section 3 of the Foreigners Act. Automatically has this statutory.
But in Abdul Khalik versus Union of India case, my lord, 2013, Abdul Khalik versus Union of India.
Abdul Khaled,
Yes, my lord. Versus Union of India, 2013, 1 GLT, my lord. May I refer this argument.
2000.
2013, 1 GLT, my lord.
Hmm.
441. And sorry, 941.
94,
94.
94.
941, 941.
What do you have to show from this?
But here this honorable court held, my lord, paragraph 8 and 9, my lord,
Hmm.
that section 9 of the Foreigners Act imposed the burden on a proceedee to prove that he or she is not a foreigner but Indian national. To discharge the burden, the appellant has examined 3 witnesses in that case, my lord. 9, the appellant in his deposition in a categorical term has stated that his grandfather's name is Abdul Wahab, whose name appears in the voter list of the year 1965, pertaining to Samaguri Legislative Assembly constituency, The witness number 2 and 3, namely Gabura and villagers of the Jusa Basti village, has proved the said voter list, which is marked as Exhibit Co. Witness number 3 has also stated that Abdul Wahab is grandfather of appellant. Such statement of witness have not been challenged by the state by way of cross-examination. Witness number 2, the Gabura of the Juli Basti, however, has stated that though the name of Abdul Wahab appears in the voter list of 65 pertaining to Samaguri Legislative Assembly constituency, he, however, does not know who is Abdul Wahab and whether he is the grandfather of the appellant. Witness number 1 and 3 having categorically stated.
This is, I think, have been clarified later. Yes. This is not the issue because it is wrong, in fact. If somebody is not a cross-examined, that is statement of the
Not controversial.
procedure and something is correct. That is
Okay.
not the way, because somehow
It was also, my lord, held in one of the Tulsi Burman case, my lord. Honorable Justice Ujjwal Bhuiya and Park, my lord. This was, my lord, held that the which has remained uncontroverted, though she have been given a chance, my lord, in that case, my lord, to
they are saying will not do.
in this case also, my lord. Page number 3, my lord, last part, last sentence, my lord, page number 3, my lord. We noticed that this testimony of the petitioner was not challenged by the state by way of cross-examination. Regarding, my lord, her father's name, my lord. Last paragraph, may I read, my lord, page number 3. While tribunal was right in discarding exhibit A1 because these two documents were not proved by the authors of the documents in accordance with law, the fact remains that in her evidence in chief, which the petitioner had filed by way of an affidavit, she had categorically stated that she was the daughter of late Chaparai and was born on to him at village so-and-so. We noticed that this testimony of the petitioner was not challenged by the state by way of cross-examination. Therefore, this evidence of the petitioner remained unrebutted. This aspect of the matter was not considered by the tribunal while disbelieving the evidence tendered by the petitioner, which has vitiated the order so-and-so. In such circumstances, we are of the view that it would meet the ends of justice if the matter is remanded back to the tribunal for a fresh decision in accordance with law. On remand, petitioner would be at liberty to prove the existing exhibits and the documents already on record in accordance with law. Accordingly, in the light of the above, so petitioner shall now appear before the foreigners tribunal. So, my lord, though any link document is not exhibited, my lord, but her claim was that, my lord, in this regard, she has adduced the documents of before 71, my lord, 66 and 71. So, my lord, my humble prayer will be, my lord, that the matter may be remanded, my lord, to give a chance, because, my lord, citizenship right is a, my lord, very important right, my lord, and that may not be curtailed, my lord, for the fault of the council, engaged advocates, my lord, litigants may not suffer, my lord. Or otherwise, my lord, I may be accommodated for 1 week time, my lord, to submit some decisions regarding this.
Possible, my lord.
Yes.
My lord, your lordship may kindly see one thing, my lord, with regard to the WS. Even though, my lord, my learned friend is arguing that I have a pleadings, there is no pleadings at all. In the instant case, there is no pleadings at all. Who is the father of the petitioner? Who is the mother of the petitioner? Who is the what is the name of the brothers or sister, if anything? And my lord, what is the date of birth? Where is the place of birth? Nothing is pleaded in the WS. So in that case, my lord, my submission will be, first of all, the pleading, the WS is not adequate. This honorable court, my lord, I would like to rely some judgment in that case, my lord. This is year 1982, my lord. In fact, I'm we may see, my lord, our High Court judgment, 2017 4 GLT 346, my lord. They are Rosminara Begum.
346.
Yes, ma'am. Numbers of judgment, then 2017 4 GLR 295, my lord.
4 GLR
295. Then 2017 3 GLR 820.
820.
Yes, ma'am. Then 2017, my lord, 5 GLR 670. All these are, there are numbers of judgments, my lord. All these are on the ground, my lord, on the issue of, my lord, WS and written statement in the foreigners tribunal. And
AR
what,
1982, what is the certificate?
my lord, this is all 385, my lord. AR 1982, all 385.
Allahabad.
Yes, Allahabad. Three- Other judgments are there are numbers of judgments, my lord, on this point, my lord. When the substance of this point was, my lord, the material facts has to be pleaded in the written statement, and whatever disclosed in the written statement, those has to be proved by adducing cogent, reliable, and admissible evidence. And they cannot traverse, my lord,
Beyond
beyond the, my lord, pleadings in the. So whatever is pleaded in the WS, that has to be proved by bringing cogent, reliable, and admissible evidence. He has not pleaded about his father's name, about his mother's name, my lord, about the about her, my lord, the brothers or sisters, if anything. She has not pleaded anything about her date of birth. She has not pleaded anything about her place of birth. So these are the materials fact which has to be pleaded in the WS, and which are, my lord, very important. The Sobananda Sonwal para 26 is clear. These are necessary for the purpose of identification and declaration of the person. So if it is not pleaded, on what basis the tribunal will declare him foreigner or not foreigner, my lord, or Indian, my lord? Second issue, my lord, the claiming of citizenship by picking up some person as my father, that will not do. That will have to be, my lord, established by bringing some evidence. My lord, kindly say this is another judgment of 2019 5 GL 1 GLT 784, my lord. 2019 1 GLT 784. This honorable court has what this honorable court has said, my lord. May I read out? In the case in hand under Section 9 of the Foreigners Act 1946, the existence of fact which should have be required to be proved by the proceeding is that concerned person whose name appears in any of the aforementioned public documents or the documents relied upon by the proceeding alone is the lineage to the proceeding. As a corollary, any evidence being laid in discharge of such burden of proof, we should indicate the lineage of the proceeding to a person merely having the same or similar name as that of the person appearing in the public documents relied upon, in our view, would not be sufficient discharge of the burden of proof to establish the existence of the fact that the person named in the referred public document constitutes the lineage of the proceeding. In order to discharge the complete burden of proof, the nature of the purport of the evidence must be such that the lineage is established not only with respect to the person whose name appears in the public document relied upon, but at the same time rules out the possibility of it being linked to any other person having a same or similar name. So this has to also to be established, my lord. Not only that person is my father, but there must be as proof that it is not the there are no other person in the same name and who may be the same person whose name is there in the voter list of 1961 or 71. That is the meaning, my lord. Whose name appears in the public document relied upon, but at the same time rules out the possibility of it being linked to any other person having a same or similar name. So that possibility has to be ruled out. And that has to be proved by bringing evidence.
Okay.
My lord, regarding the WS, my lord, I intend to place a judgment, my lord. Today I have not done one of the
Sure, why not?
Hyder Ali, my lord. So, my lord, passed by the Honorable Justice Kuteshwar Singh, my lord. My lord, may I pray for my lord 1 week time, my lord, to my lord place some of the judgments, my lord, on that
Give the judgments on Monday at 2 o'clock
Monday.
or 3 o'clock.
Obliged. Well, can it be on Tuesday, my
We
lord?
have concluded already.
My lord, can it be on Tuesday, my lord, on
We
Monday?
are concluding it, but
Yes.
you can always give.
Obliged. Well, can it be on Tuesday, my lord? On Tuesday, my lord? On Tuesday, my lord, can it?
Tuesday. Oh,
Okay.
give us, no problem. Heard Mr. Pradeep Council appearing for the petition. And Mr. Tepai. MJ Katir. Mr. H.
Obliged.
Okay. You wait for two. We'll make this materiality and
there be directly tribunal that the tribunal shall not admit any fresh evidence or documents and it is further directed to pass the opinion without being influenced by the observation of the school. And with that observation, it is present in this court. And interim order earlier is also merged with this order.
the matter has been remanded back.
It will be remanded.
Item number 2.
In the other matter which my sister has just delivered, there here she have to see that the only the things reappreciation of whatever the evidence is there, nothing new. That is very.
In that point that the entire evidence on record were well appreciated by the learned member foreigners tribunal. And accordingly, we do not find any reason to interfere, make any interference, and thus the petition then dismissed and interim order passed earlier by order dated 2020.
These things you have to communicate clearly.
Item number 3.
In this case also, we didn't find any reason to make any interference, and accordingly, the petition stands dismissed. And the earlier interim order also by order in the order dated 11/10/2023 also stands. We find that the learned foreigners tribunal Lorong Mongoldoy has arrived at a correct and just decision, and thus we do not find any reason to make any interference and petition stands.
Petition dismissed. Prayer for bail stands rejected. In the matters where the LCRs, in this matter, LCR is to be handed over to probably Ms. Verma. So you'll get the LCR by Monday, or if she is available, she can get it now. If she is available, ask her to. Today she is not available. So then Monday,